And joining us now here in studio, Grant Huscroft. He is professor in the Faculty of Law at the newly renamed Western University. Thanks for taking the train in from London today.
Thanks very much.
Let's start with an excerpt from Christy Blatchford's item in the National Post about this, and then we'll talk after that. It was just before 2 in the morning on March 9th, 2009, when Mr. Smickle was visiting his cousin's apartment. The cousin decided to go out to a club. Mr. Smickle stayed in and then did what any guy his age, he was 27 at the time, would do. Wearing shades, a pair of boxers, and a tank top, he posed for a picture for his Facebook page, a loaded handgun in his left hand. Poor Mr. Smickle. Members of the Toronto Police Guns and Gangs Task Force were onto his cousin and busted in on a search warrant to find themselves facing the gun. They used a distraction device which went off with a bang and ordered Mr. Smickle to the ground and to drop the weapon, commands he obeyed with uncharacteristic cleverness. Okay, let's go through some of the particulars of this case before we discuss the sort of wider-reaching significance of it. Smickle is caught in the possession of a loaded handgun. Legally speaking, why was this an especially ticklish situation for him?
Well, the problem for Mr. Smickle is that the law establishes the potential for a 3-year minimum sentence of incarceration. It's possible that he could get a lower charge on the same offense, but if the Crown proceeded by indictment, which they did in his case, the minimum penalty is 3 years.
So this is what mandatory minimums are all about?
This is an example of mandatory minimum in operation.
So even if you're doing something which you think is just kind of cute and funny, posing for a Facebook picture with a loaded handgun, 3 years?
Well, you know, one of the things about this case that's problematic is that the facts are being portrayed and spun in a way constantly that I have some doubt about, to be perfectly honest. If we're paying attention to the facts here, even as Christy Blatchford recounted them, this is the gang squad coming to the house of a bad guy who has illegal handguns there. They have to batter the door down 3 times, come in, they have to use a distraction device because they see there's an armed man there.
What does that mean, a distraction device?
I don't actually know. According to the court case, it's just something that goes off, distracts them, and then allows them to disarm him if need be. But Mr. Smickle cooperated, so it wasn't an issue there. But he's found with a gun that's not only loaded, but it's cocked. So I'm not underselling how serious a situation that is, and that puts officers in danger. You know, it's the gang squad coming to a place where something bad is going on. It's being spun as poor Mr. Smickle doesn't know anything about any of this.
But there's a little more to it than that.
Well, I don't know. But in terms of what the judge found, in her view, Mr. Smickle isn't innocent in all of this.
Well, let's go through this again. The handgun possession law is a so-called hybrid offense. What does that mean?
Hybrid offense means that the Crown can proceed in either of 2 ways. They can proceed to a summary conviction trial or they can proceed indictably. If they proceed indictably, that is the more serious way of going, and it usually involves a higher penalty. The Crown might proceed on a summary matter if they think it's a lesser serious offense, if they think the circumstances warrant that, if there's a public interest in doing so. There's a number of considerations that might suggest to the Crown that they should go summary. In this case, they went indictable.
They went for the more serious one here, despite the fact that, and Christy Blatchford, I gather, sat through the trial and heard this, so she has him portrayed as being a, quote, hapless doofus. Gun cocked notwithstanding in a place that he probably wouldn't want to be caught in. So there's some different interpretations about what's potentially going on here, right?
There are. The Crown argued at the trial that one of their theories was that Mr. Smickle had the gun outside of the apartment, had been walking around the street with a loaded weapon, which would make it quite a serious offense, it seems to me. That's an aggravating factor in how serious this would be. There was also a suggestion at the trial that maybe he cocked the gun when he thought the police were at the door, which again would make it a very serious matter. The judge found otherwise. The judge concluded, as a matter of fact, that in her view, the gun was there at the apartment, he just happened to pick it up, and it's all very innocent.
Talk about wrong place, wrong time type of thing.
If that being the case, that's terribly unfortunate for Mr. Smickle.
Because you don't want to go away for 3 years for doing something that inane.
But again, in the normal circumstance, Crown's prosecutorial discretion would kick in here, and you'd get a lesser charge. And on the lesser charge, if he's charged as a summary matter, he can get anything from nothing to 1 year.
Well, should the rest of us who are not schooled in the law be concerned about the fact that there are defense attorneys, Crown attorneys, judges, perhaps well-known university professors who have a fundamental disagreement about what actually happened here?
No, I mean, the law operates on the basis that the judge is the trier of fact. And I accept what the judge's facts are. I'm just saying it's from the police's perspective, when they came, they had a particular understanding. They think they're breaking into a place where there's illegal weapons, and they're right. It turns out that there's an innocent person in the place, but he's holding a weapon. I mean, I don't want to split hairs about how serious that is. That's serious. Yes, there's an innocent explanation, but they can't be expected to know that. The question then comes at the prosecutorial end of things. What should the Crown have done? And it looks like, in retrospect, the Crown ought to have, you would have supposed, gone for the lesser summary offense. Now, the thing that's important to emphasize here is that he is not considered such an innocent that he should have got nothing. Because even this judge said, I would have given 1 year. 1 year. So we're only arguing here now about the difference between the 1 year that she would have given him and the 3 years that the legislation said he had to get as a minimum.
Okay. Smickle appeal, right? He appeals this to the Ontario Superior Court, which overturns the ruling of the lower court, a ruling that was described as cruel and unusual punishment, the heavier sentence described as cruel and unusual punishment. What would have been the argument in this case that would have suggested that this was somehow cruel or unusual to give him the full 3?
The law on what makes something cruel and unusual in Canada, well, first of all, this is a really problematic phrase. It's an old phrase. It's the Bill of Rights 1688 phrase. And back in that day, cruel and unusual meant, barbaric things like drawing and quartering or stoning or torturing or something like that. We're miles and miles from that. In the modern time, judges don't say, what does cruel mean or what does unusual mean? They say, we think that a sentence is cruel and unusual if it's grossly disproportionate. So they've introduced a new term. And so gross disproportionality comes in, and notice that it's not just disproportionality, but it's gross disproportionality. So that means the suggestion there from the Supreme Court is that something has to be really outrageous. And then they bandy phrases around like an affront to decency or these sorts of an affront to ordinary Canadian sensibilities who would be outraged and so forth. And that shouldn't happen very often in Canada. And you wouldn't, in short, you wouldn't expect to see many cruel or unusual laws being passed in modern times by Canadian Parliament.
But you do?
Well, here's the problem. The concept of disproportionality invites judges to weigh things, right? And we're weighing things that aren't really commensurable. You can't weigh them. How serious is this in all of these circumstances? And then it says, don't declare something unconstitutional because of that, only if it's grossly disproportional, way, way out of line. And that stems from the first case that they did, in which the court looked at this, a case called Smith, where there was a mandatory 7-year jail term, mandatory, for possession of a quantity of drugs. And Mr. Smith in that case had, as I recall, a very, very large quantity of cocaine. There was no way that there was a real concern with him, but the court said, we can't just be concerned with the person who's in court. We have to be concerned with a hypothetical case that might arise. And Chief Justice Lemaire, I think it was, said there might be a case where a young person on vacation from the tropics comes back with a single marijuana joint, and that person would get 7 years. And that shows that this law is grossly disproportionate, even though the person before the court was not that person, got the benefit of it. So that's what the court now does. It goes through 2 questions. It says, is the sentence for a particular person grossly disproportionate because of the minimum? And if not, would the minimum sentence be grossly disproportionate in a reasonable hypothetical case? In this case, Judge Malloy said, in the circumstances of Mr. Smickle, he should have got 1 year, in my view. I'm required to give him 3. I find 3 to be grossly disproportionate.
But I got to give it to him anyway.
But I have to give it to him.
Is there not some kind of constitutional provision that would allow the judge to say, I'm exempting you from this law?
The court struggled with that for some time, and some lower courts were starting to look like they were interested in the idea. And the Supreme Court, very recently, in a case called Ferguson, said, you can't carve people out of the law on an ad hoc basis. We're not going to allow the constitutional exemption idea. So they're in a bit of a box now. If you pass a minimum sentence that looks harsh in the case of a person or a hypothetical person, the only thing you can do is strike down the whole law. So the benefit of the law is lost because, in the worst case, you could hypothesize some ridiculous character for whom this would be a bad penalty. My concern about this case is that, about the court's approach in general, is that it's pretty hard to determine proportionality. That's a bit of an eye of the beholder thing, and I think reasonable people can disagree. And here we're only talking about 1 year versus 3.
Well, that's still a lot of time if you've got to serve it.
It's not taking into account parole, for example. A judge doesn't do that, didn't do that. I mean, I don't want to minimize 3 years imprisonment. That's a big, big penalty.
Yep.
On the other hand, if we compare that to the first case where the court invented the idea of disproportionality, that was a case of comparing a single marijuana cigarette for which no one would do any jail time, but would be required to do 7 years in that case. That seems grossly disproportionate. We would all agree on that. Just like I think we'd all agree if we said the penalty for shoplifting is life imprisonment, everybody said, well, that's grossly disproportionate. But nothing is like that in real life. Everything is a real smaller comparison. So would 2 years be grossly disproportionate rather than the one she wanted to give if 2 years were the rule? It's double, but is it?
Right, but it sounds like they're trying to clamp down on judges freelancing their own ideas about how much sentencing should go on.
Absolutely. But you know, I want to make the point, it's not, this government is not doing that in some sort of new way. There have always been minimums in the law. There's minimums in firearms offenses, there's minimums in sexual offenses against children.
But there's higher minimums now.
And they're raising some of them,
yeah,
and they're creating some more minimums. But minimums aren't unusual. You know, the problem is it's a big country, and with a wide range of sentencing discretion, you are going to get some sentences that look like outliers, some very modest ones for a similar offense that result in a very higher one in another province. That's a problem, and
well,
sometimes...
Does that mean you can't really write a good law that will cover any number of different eventualities, be they happen in British Columbia or Newfoundland and Labrador, and therefore, what, we shouldn't try?
Well, it's a tough one, but here's a thought. If you're going to have a minimum sentencing regime, a good idea would be to build some criteria into it. This one just said flatly 3 years, if you've got a gun, a restricted firearm. If instead you had said, here are some criteria, if the judge finds that it was loaded, if the judge finds that it was cocked, if the judge finds, or you know, you could make up some relevant criteria there. You can't possibly anticipate all the ones you're going to need, but if you had some, then there'd be something for the judge to do before just automatically having to impose that sentence. But I want to emphasize that the thing that makes the criminal justice system work anyway, even if you have minimums, is prosecutorial discretion. And in most cases, you don't hear of the Mr. Smickles because the Crown would have gone a summary conviction route, and he would have got his 1 year in jail or something lesser.
Gotcha. All right, well, in which case, let's, just in our remaining time here, have the overarching discussion, less about this particular case, but many people have seized on this case as a good example of why it doesn't make sense to have such high mandatory minimums. What's your view on that?
Look, I think I'm not opposed to the idea of mandatory minimums in principle. I think they've got to be done sensibly and well. I think that this one is problematic. This one looks, but I'm also reticent to call it cruel and unusual punishment. That's a term I'd reserve for much more harsh things, I think, than this. I would say this is a harsh penalty. Do I think Parliament should revisit it? Yes, I think they should, because we've got an anomaly here. The same offense either gets a maximum of 1 year if you proceed summarily, or a minimum of 3 years if you proceed by indictment. So there's like a 2 year jump. That seems odd to me, and that seemed odd to the court, and I think the court's quite right about that. Seems arbitrary.
Well, there is an omnibus crime bill before Parliament right now, and the Conservative government obviously has mandatory minimums as a key, foundation as a part of that bill. Do you think this ruling, the Smickle case, ought to affect what happens in that bill?
Well, I think this case will be appealed. I think this will go all the way up, this and or other related cases, because the court, I think, has to revisit its approach to minimum sentences. I think the reasonable hypothetical problem, I think that approach is problematic. Let me put it that way.
Go a little further. What are you saying?
Well, look, it's not clear to me why somebody before the court who is deserving of whatever the relevant penalty is should be declared a victim of a constitutional breach because the judge, in their imagination, can conjure up some poor soul for whom this would be a harsh penalty. Oh, so I find that sort of odd.
Okay, so I'm trying to find out where your key area of criticism is here, and it doesn't sound like your key area of criticism is with what the Conservative government is trying to do or the idea of mandatory minimums. It has more to do with what, the way judges are interpreting or the discretion that Crowns have in these cases?
Well, Crown discretion is a feature of any regime you're going to have, and it makes the system work with plea bargains, agreements, agreed sentence submissions, and so forth. So that's always going to be a feature of this. The other thing that's always going to be a feature of it is that judges really like their discretion. They don't like anyone telling them what's what. So we've got this idea that has come into our constitutional law via the judges that a grossly disproportional sentence, in our view, is unconstitutional, and yet the government, and it's a majority government and ran on a law and order type platform, says the people want minimums. So the court has to allow minimums, and they will. They say it's not our job just to declare something unconstitutional because we think it's excessive. They say it's got to be grossly disproportionate. And all I'm saying is that that is a moving standard that different people, different judges are going to see differently. And I think great care has to be taken. Otherwise, you completely undermine the whole idea of minimums.
But presumably the Conservative government is going after this as aggressively as it is because it sees that, in particular, its supporters feel that the courts over the years have been far too lenient and therefore they need to do something about it. That's fair to say, isn't it? Do you think the courts have been too lenient and therefore the government feels obliged to do something about it?
You know, I'm reluctant to do a broad brush on that. I think there's some sentences where people think it's way too low. I think that, you know, minimums on sexual offenses against children, I think that's a great idea. I think some automatic sentencing is a good idea, and I'd prefer that to some judicial discretion. On the other hand, I think it's good that there are some offenses for which there's a range of sentencing options. I'm still worried about disparities in the way that judicial discretion is exercised, but I think that's better than trying to anticipate. You can't anticipate as a lawmaker everything, and there will be bad cases that come up.
Remember in California, 3 strikes and you're in?
Yes.
So do we need something like that here?
No.
You didn't like that approach?
I wouldn't.
It was a very conservative approach.
But you know, I'm not making a conservative argument here. My argument is just on the Constitution. I think reasonable people can disagree about the length of a sentence. I have no problem with that. So, Canadian sentences are very short compared to some American ones. They're very much longer than some Scandinavian and European ones. It doesn't mean anybody's right or wrong. It means reasonable people deal with their own problems in different ways. What I think is problematic is insisting that the Constitution forbids certain outcomes here. I think if we're going to have good democratic debate and discussion and agree, here's what we should do, then let's do that. But only if it's grotesquely out of line ought the court to be coming in with the Constitution. I think mere disagreement that these are a bad idea, and the criminologists say they don't work, and I understand the evidence, but mere disagreement as a matter of policy doesn't render something unconstitutional.
Gotcha. Grant, thanks for coming in tonight. Appreciate your time.
Thank you very much.
Grant Huscroft from Western University.
Support Ontario's public television. Donate at tvo.org.